Should have had a more exciting slide up, shouldn't I?
Fantastic. Wow, that's Good evening, everybody. We are still waiting for a few people to come along, but they will join us. And I like to run a tightish ship if I possibly can. So, welcome. Thank you very much for joining us here at Petersfield Museum for this very interesting talk. I'm very excited to find out more about it. Just to let you know that we're not expecting any fire drills tonight, so if there is a fire alarm, then your fire exits are situated through there, and either myself or one of my colleagues will help you go in the right direction, and I shall make sure everyone is safe. No one needs to be a hero. That's my job. If anyone needs the toilets through, you can go just through there. I'd also like to say hello to those of you who aren't in the room. So this talk is actually being live streamed to a digital audience, so hello and welcome. I will be, once I've done this introduction, on the chat, so if you are having issues with the quality or sound, please let me know, and I'll be doing your tech stuff at the back, so do welcome. And also, this talk will be available for all ticket holders for at least a week after the talk as well, and I can send you the link, so you can go back over it and find out all the details that you can possibly want, not to daunt you at all. That is out there for the live public. But it gives me great pleasure now to hand over to our speaker tonight, who is Peter Jolly, who will do a much better job of telling you who he is and what he's going to talk about than I will. So thank you very much, and Peter Jolly.
Thank you very much. Can you all hear me?
Yes.
That's a good start, isn't it? Yeah. This brings back memories, because 50 odd years ago I used to stand here appearing in front of a local bench in this very room. I'm Peter Jolly. I currently lead a local history group of U3A, and our group produced, and David Jeffrey and I edited a book on College Street many years ago. And my historical, as it were, pedigree is limited to what I have done since retirement, and I'm currently on my way, touch wood, to a history doctorate. Anyhow, this is a story that is encompassed in this little book, which the museum kindly published a while ago, with a few little extras involved in it. Right, okay. On the 28th of February 1874, the Hampshire Advertiser wrote, "Our new member, the Honourable William Sidney Hilton Jolliffe of Heath Lodge near Petersfield, is returned in the Conservative interest for the borough of Petersfield, in the place of Mr. William Nicholson. He's the second surviving son of William, First Lord Hilton, who was formerly MP for the borough, by his first wife Eleanor, who was the daughter of the late Honourable Berkeley Paget and niece of the first Marquis of Anglesey, K.G. Nothing like name dropping there. And you can probably guess, therefore, who the Hampshire Advertiser supported. In parentheses, at the foot of the paragraph, is a little note that the Liberals have presented a petition against Mr. Jolliffe's return. And this is the story of some of what followed, and how it shone a light upon local life here in our small town, mediated through some slightly more objective reports of proceedings in the press. And that's what the Hampshire Telegraph reported. But first we need to explore a little bit about the context, historical and geographical. The Jolliffe family, ancient lineage, first granted lands in Staffordshire by William the Conqueror, but their significant association with our town arose in the early 18th century. And in 1734, Sir William Jolliffe, keep on carrying on the same name, a rich merchant and banker, on the interest of his nephew John, became MP for Petersfield. John had inherited from his first wife a number of burgages, and in 1736 he strengthened his hold on the constituency by acquiring from Edward Gibbon Sr. further plots, and ultimately the lordship of the manor. And it was Sir William in his will who made provision for the erection of the statue of William III that we can see towards the top left of that picture of the market square. That picture I originally thought was pretty close to 1874, but the more I investigate it, it's likely to have been about the turn of the century, but nothing significantly changed between those two dates. Anyhow, that statue, of course, as many of us will know, used to stand in the grounds of Petersfield House, which effectively was situated right here, where we are sitting and standing. In the 18th century, Petersfield, the Parliamentary constituency, returned 2 members to Westminster, and until the first Reform Act of 1832, there were only 7 years in which a named Jolliffe was not the first member for the borough, and quite often Jolliffes held first and second seats in the borough, either themselves or with a nominee. So Petersfield was in reality nearly as rotten a borough as Old Sarum or Newtown, Isle of Wight. In the 1831 election, 29 of 36 voters, that's all, cast their ballots for William and Hilton Jolliffe. Now, as the franchise was concentrated on freeholders of the burgage plots, issues had already arisen as to the legality or otherwise of subdividing premises. That way you created more votes. Bogus plots existed in the marketplace, marked only by stones granting voting rights. And on this there had been a previous challenge in 1820. But unlike Old Sarum and Newtown on the Isle of Wight, when the redistribution of seats was addressed in the 1832 Act, the pocket borough of Petersfield, by the skin of its teeth, retained the right separately to be represented at Westminster. The boundary commissioners had commented that the town had but little trade, and any consequence that it possesses arises entirely from its lying on the high road from London to Portsmouth and from its returning at present 2 members of Parliament. However, the price for its continuing separation from the county constituency would be that henceforth it could only send a single member, and the constituency would be enlarged 100-fold from the tight confines of the borough, which is the 237 acres. It stretches a little bit up towards Dark Hollow, but otherwise it's virtually all comprised here. Dropping down, this is the boundary of the borough. Anyhow, it was extended to about 35.5 square miles and included Brereton, Sheet, Steep and Liss, with the tithings of Ramsdean, Oxenbourne and Languish. The electorate, therefore, increased a little bit, but the population was 4,400 at that stage. The electorate, however, would revolve around 298 what are called £10 houses. Because some of these were owned by the same people, then the electorate in fact rose to the princely number of 234. However, even with these adjustments, it was the least consequential borough to retain a single member in 1832. And in 1874, it seemed that the single member elected would be a Jolliffe, with a majority of just 11. That's the votes that were actually cast in the 1874 election. But what a difference the 1832 Act had made. In the first ballot after the 1832 Act, there were 201 voters, and 101 of them cast their votes for the Whig John Shaw Lefevre, a majority of 1 over William Jolliffe. But that poll too was challenged, and Lefevre was unseated. In the next election, Jolliffe lost by 16 votes, but when it came to the 1838 election, lightning was struck for a second time. 249 voters then, they were divided 125 to 124. A single vote majority again. And again, would be a challenge to it and it would be overturned. This time Jolliffe was the loser, but this excitement, far too much for our little market town, and Petersfield settled down to representation from 1841 to 1865 by William's nephew, another Sir William Jolliffe, who remained the member elected unopposed. But by 1866 he served in Lord Derby's government and was raised to the peerage as Baron Hilton. Net result, by-election. And in 1866, sadly, there was no Jolliffe around to stand in his stead. Eldest son, surviving son Hedworth, was already in the House of Commons as MP for Wells, and Captain Jolliffe, who would contest the 1874 election, was still in the army. So, the Liberals had taken the opportunity to approach William Nicholson, whose picture you see, in fact, on the plot behind, under the heading Magistrates, the wonderfully bearded figure. He stood and took the seat. He was a member of the J.W. Nicholson family firm, famous for its gin distilling. And in 1863, he'd acquired Basing Park, near Privet. He was a sometime first-class cricketer for Middlesex, and he's famously known as the man who saved Lords. Because in 1866, he lent just over £18,000, on any computation worth well over £1 million now, to prevent Lords from being commercially developed, and so that the freehold of the cricket ground could be bought. He saved Lords again in the 1880s. So, but for him, the country might not have witnessed the first Test match at Lords in 1884, when England actually beat Australia by an innings and 5 runs. And one of the more sensational Test match climaxes, which some of us may remember of a certain vintage, though it's largely been eclipsed by the Bazball heroics, 1963 against the West Indies, where we were chasing 230 odd to win, 2 balls left, 9th wicket goes down, and Colin Cowdrey has to come out to bat with a broken arm. Anyhow, there we go. Nicholson saved Lords not by his cricketing exploits, but by his financial acumen. So, we know in 1866 he was returned unopposed, another election in 1868, contested by Conservatives, but still no Jolliffe around, so they lost by 150 votes. Now we start coming up to date, as it were. We've got some important changes in the decade before the 1874 election. There'd been no provision for a secret ballot until then. Everyone knew who you voted for, or if you voted even. And so consequently, if you were employed by or a tenant of the family of one of the candidates, you were expected to vote for them, otherwise you might lose either or both of home and job. And for many £10 householders, therefore, they had little choice for whom they voted. And so large landowners continued to manipulate the entire election. And if there were to be a challenge to the validity of the result, equally, the challenger would know who they were challenging and for whom they had voted. And that had been the regime back in the 1830s, and that's why the single vote victories were easily overturned. The second factor we can see there is the Representation of the People Act of 1867. Those of us that even studied O-level history will perhaps recall that the 1832 Act was of really great importance. It was the first change to the electoral system, but it only enlarged the franchise nationwide from about 400,000 to 650,000. the 1867 Act nearly doubled the franchise from what was then the best part of 1 million by another 938,000. And it was this enlarged electorate that would decide the 1874 general election. It's one of the many ironies of that election that the Liberals nationally won 55% of the popular vote, but lost the election because there were 100 seats in which the Tory was elected unopposed. And that's the only time that's happened since we've had the secret ballot. Now, in borough seats such as Petersfield, what the 1867 Act did was to extend the franchise, as you can see on the screen there. But there remain still various personal disqualifications. Today we can still think of those peers or some felons. And it's these constraints and limitations that would engage lawyers for several months in the spring and early summer of 1874 as they argued over the Petersfield borough result. Now, the Petersfield borough constituency embraced several neighbouring villages, and we have the Hampshire Telegraph reporting on the 29th of April that witness after witness appeared in the witness box in his smock fresh from the plough table. Now, without undertaking a complete transcription and analysis of census entries for all the communities within the constituency, we can delve into the situation in Petersfield itself in a little more detail. Okay? Try and go back to that image so you can see how Petersfield had developed. That's from, I think, the 1869 survey. So it's pretty accurate, and you can tell that the developed area was really the High Street, what is presently St Peter's Road, but is called New Way. A few cottages down what was Golden Bull Street, Sussex Road, and the developed area, apart from a little bit up near Churches College, lay on the Drum Stream, which was the end of the Burbage plots. And you can see the railway station up there, not accessed by Lavant Street, but you got there by going up Chapel Street and turned left along what had been renamed for that section, at least Station Road. It still remains a wonderful name, Cow Lakes Lane, on its route to Churches College. So what have we got? This area, about the size of 160 football pitches. We had petty sessions held fortnightly, then at the town hall in the square. Clerk to the magistrate, Joseph Soames, was a busy man. He was also clerk to the Commission of Taxes, Burial and Highway Boards, Rural Sanitary Authority, clerk to the Poor Law Union, superintendent registrar, births, deaths and marriages, county court registrar and vestry clerk to the parish. Two of the town's doctors, Thomas Moore and Albert Leachman, were medical officers of health. Despite the railway, carriers still operated to Farnham, Guildford and Portsmouth. We had 13 insurance agents and auctioneers, 2 solicitors' practices, 10 inns, 3 hotels, the railway, the Dolphin and the Red Lion, as well as 2 banks. A cooper, saddler, harness maker, coach builder, several bootmakers, watching clock maker, basket maker, umbrella manufacturer could all be found, as well as the usual pig, corn and hay dealers, grocers, wine and spirit merchants, maltsters, bakers, confectioners and the like. And we can see down, you notice there's a brewery there, and we've got the malt houses there off Dragon Street. And there were the usual tradesmen, wheelwrights, carpenters, plumbers, etc. In 1881, there were 1,646 inhabitants in the town. Slightly more than half of them were female. 524 were married, 29% were 15 or under. 97% had been born in England. Something like 2/3 of those had actually been born in Hampshire. Another 169 in West Sussex. The workhouse, which is up top right, just the other side of the Midhurst line, embankment, which is still obvious if you go to the community centre. The workhouse housed 75 people. What were the employees like? Well, there were 126 female domestic servants, many of them under 20, several laundry maids, cooks, etc. As far as female employment was concerned, there were 40 engaged in dressmaking, tailoring, and just 11 in education. The male population, 773, 530 gainfully employed, chiefly in the provision of food, drink and lodging, building trade, and 59 in the transport of goods and messages and the like, some by rail, some by coach. So this was the setting which the proceedings that took place were reported nationally. It was to be the first scrutiny that had taken place under the new Ballot Act, and Henry Stowe, a school teacher living in the square, had nominated Nicholson for the election, and on his behalf challenged its validity. Now there was another statute that becomes relevant, the 1868 Parliamentary Elections Act. Previously any challenges had been dealt with by a House of Commons committee. Now they had to be dealt with in the constituency itself. So one of Her Majesty's judges would come to the town and sit for 5 days hearing evidence in the Corn Exchange. The Corn Exchange, which you may know, is the building effectively where Cuban West currently is, on the corner of the square. But after the 5 days there, there'd be a further 3 days in the Court of Common Pleas before the Lord Chief Justice and 2 other judges, which resulted in a decision on the interpretation of the Ballot Act that, in fact, in some areas still holds good today. It's Stowe versus Jolliffe. However, before the judge, Mr. Justice Mellor, could arrive at Petersfield on the 21st of April to hear these allegations of bribery and undue influence, the Court of Common Pleas had been asked to consider a preliminary point. You see, the 1874 general election was the first to be conducted under the new scheme, and how was any challenge to be worked out? What was the procedure? Because we got a secret ballot. How would you overcome this if you were going to challenge? There were lots of technical arguments, but in short, the clerk to the Crown in Chancery, the official that held all the election documents, was directed to open the sealed packet that was alleged to contain the marked register of constituency electors and permit both sides to make copies of it. The Hampshire Telegraph reported that the little town of Petersfield is in a state of extreme perturbation. Certain of its inhabitants alleged that at the late election for the borough there was scarcely fair play. They've accordingly petitioned for an inquiry into the matter. And it then went on to explain how investigations of this nature are no longer conducted in London. They say, at all events, no judge has ever entered Petersfield before as a judge. And of course, when Mr. Justice Mellor arrived, as he did shortly after 1 o'clock on Tuesday afternoon, he found that Petersfield had turned out to do him honour. Now, I'm not at all certain that by the standards of today, the hearing was impartial, because given the extent of Jolliffe landholding in the centre of town, the judge's specially prepared lodgings in the Spain were probably a Jolliffe property. Anyhow, there we go. Let's just move on. The conduct of the hearing. It would be in two parts. The first would deal with bribery, etc. And if that failed, then there'd be a second part dealing with the scrutiny and the entitlement of individual actually to vote on the occasion. The first afternoon of the hearing was taken up with Sergeant Ballantyne, who acted for Henry Stowe, outlining the history of the seat and the control that the Jollifes had exercised over many, many generations. Of course, the Jollifes weren't alone in having influence in the town. Mrs. Nicholson had paid for the substantial refurbishment of the parish church, reopened only a matter of days previously. Anyhow, what Sergeant Ballantyne went on about was the efforts allegedly made by Jollife's family and his agents to offer alcoholic refreshment in exchange for votes, small cash payments in exchange for votes, and overall, some allegedly pretty unsubtle and improper pressure. I'm going to focus on just one or two of these. Let's go back to this. So if you get bored, you can look at the map in more detail. James Locke was landlord of the Golden Horse in the square sitting right next to the Corn Exchange, where Fat Face is at the moment, I suppose. He's a cordwainer by trade, and he told the inquiry that on the night of Captain Jollife's meeting in the very building, the Corn Exchange, Thomas Moody had gone next door to his house to encourage him to vote for Jolliffe. Now, to much amusement, the account was given of a light-hearted exchange between Moody and Locke. Locke said he would vote for Jim. Now, that statement is capable of misinterpretation because, as we know, Locke was not only a publican, but Nicholson was rather closely associated with the manufacture of gin. Moody told Locke to bring out a bottle, and he paid for it, 2 shillings and 9pence, which was unheard of generosity on the part of that man, who'd previously only ever been seen to offer hospitality to the extent of 3pence worth of brandy. And then on the day of the election, Locke was visited by the son of the landlord, and the election was discussed in general terms. But I suspect, to the chagrin of Sergeant Ballantyne, Locke denied that he'd been influenced in the way that he had voted. The name of William Carter comes up later. He was the sub-agent of Jolliffe, and Sergeant Ballantyne doubtless had in mind a provision of the 1867 Reform Act which prohibited any elector who had, in the previous 6 months or during the election, been retained by or employed for election purposes for reward from himself voting. Carter, and also William Caplan, a Carter adjoiner, who'd been used by Jolliffe as a bill sticker, they were both, in fact, potentially subject to this provision. But it transpired that neither of them had received anything more than their due wages. So that particular angle of approach didn't work. I mentioned William Carter. His name looms large with Richard Gould. Richard Gould lived in the churchyard, close to what used to be Flora Tort's cottage. A labourer in his mid-40s, his wife Mary, and they had children. He was and had for some time been a monthly tenant of Lord Hilton, that's the Jolliffe family. William Carter had been agent and rent collector for the Jolliffes, and he had first installed Gould in the cottage at a weekly rent of 1 6pence. At that time, Carter had inquired of him that in the event of an election, the Jolliffe family wanted a vote. Would he cast one for them? Now, we might think that as this conversation took place just before Gould was granted the tenancy, he'd inevitably agreed to committing his vote to Jolliffe to get the house and keep a job. The poor man had been trying for ages to get a house of his own. But subsequently we hear that this conversation took place not in 1874, but in 1862, when the limited franchise would not even have included a man such as Gould. So despite the fact that this took place in seemingly inauspicious circumstances, all was taken with amazing prescience of forthcoming legislative changes, both to grant Gould the vote and to create a secret ballot, Gould nonetheless maintained his evidence under cross-examination. So his wife Mary was called, and she said on the 29th of January, that's at the time of the poll, she was visited both by Carter and Captain Jolliffe, and surprise, surprise, they asked if her husband would be voting for Jolliffe. I've got a sneaking suspicion that she wore the trousers in this particular family. She was able to say that he's been away quite a lot. I haven't discussed it with him, I don't know. She did say, however, that he didn't understand too much about these things. Carter, of course, stressed that this had all been decided when they took the cottage, hadn't it? But Mary was up to it and said, I know nothing of that. When husband returns at tea time, she tells him all about it. And Counsel for Henry Stowe urged upon the judge that this conduct clearly offended the Corrupt Practices Act. Because we've actually got the elected member personally participating in the allegedly corrupt January meeting. But that was a high point of the case for corruption, bribery and treating, and asked to respond for Captain Jolliffe. His barrister thought the case was so clear-cut that no need to call any other witnesses. And for the lawyers amongst us, that will mean, of course, if you don't call any witnesses, they can't be cross-examined, and they can't let the cat out of the bag in the cross-examination and incriminate your own client. So the barrister for Jolliffe simply said, no case to answer. And try as he might, Sergeant Valentine for Henry Stowe could not convince the judge that even 6 months' worth of ale was not small beer for an agricultural labourer on 10 bob a week, and that all the instances that have been shown to the judge, including dinners for townsmen over 5 nights at the Red Lion, costing 21 quid, charged to Hedworth Jolliffe, and sessions at the Trooper Inn and at the Creditors, and alleged payments on behalf of Jolliffe by the aptly named Captain Money to get men from list to vote. That's an allegation that was very much disputed. This was all to no avail, and Justice Mellor threw out that aspect of the case. Undue influence related to the tenancy to Richard Gould, and the judge surmised that if the granting of the tenancy in the circumstances suggested had indeed taken place close to 1874, he might have viewed matters differently. Nonetheless, he didn't feel that in the circumstances that amounted to undue influence. So, let's move on, because if Stowe didn't succeed on that, we had to look at the scrutiny on individual votes. Following day, Thursday, the Corn Exchange was densely crammed, as reported even the Huddersfield Chronicle, and the judge started hearing the entitlement of the various voters to vote. And this was the lottery, and this aspect was actually reported in the Times. I won't do all the quotes to you, but we're told that when objections to Mr. Nicholson's voters were taken, great laughter was caused by several votes which were objected to on the basis that they were given for Mr. Nicholson, being found to have been given for Captain Jolliffe. What, as this was a totally long procedure, the judge decided to do was decide matters of fact in relation to these individual voters, but would reserve a final decision on the interpretation of the Ballot Act to later. In other words, he did the scrutiny and he had a provisional result, and then the Court of Common Pleas would have to decide whether it had been appropriate to do the scrutiny in that manner or at all. Our interest as social historians and observers flows from what went on Thursday, Friday, and indeed into Saturday. If men had received parish relief since the end of the previous July, though they'd been on the register beforehand, and theoretically enfranchised by being on the voters' register, they were debarred from voting. And so the votes of Edward and Henry Colwell were both struck off. The former because an order had been made by the Board of Guardians for medical relief. That was on the confinement of his wife. And a doctor had been in attendance on the wife of the latter. Cases such as this imply that ordinary working folk on agricultural wages often had to rely on outdoor relief under the Poor Laws to obtain medical assistance, and even post-attendance ratification by the Board of Guardians constituted disqualification through medical relief. Objection was also raised to the vote of George Money. If that's mine, I apologise. Now, medical assistance had been afforded to George Money's son, a groom, who went home ill one day and sadly died at his father's house. Now, the judge didn't feel that relief given to a working man, a working son, amounted to a benefit to the father from the poor rates that would disqualify him from voting. List labourer Frederick Powell had his vote taken away as his wife was in the county lunatic asylum. But disqualification from voting was probably the least concern of labouring families unable to afford the basics of life on poor agricultural wages. And many were the instances of votes being challenged on account of medical relief having been given, and the extent to which the ordinary working man often depended on the new poor law for only available help for medical purposes was incredible. I'm going to digress for a moment, and I don't apologise for it. On the same page that the Hampshire Telegraph was reporting the proceedings in the Corn Exchange appeared the sad story of 67-year-old Mary Day. Her husband was a labourer on a farm near Lasham near Alton. But for the last 5 years, for want of accommodation, they had been sleeping rough in sheltered spots on his employer's farm. Latterly, in a makeshift shelter of a few hurdles and some straw for a roof. Mary Day was perhaps unsurprisingly taken ill. Her husband applied for an order for parish medical relief. It was refused. The relieving officer there did, however, send word to a local doctor, Dr. Leslie, who was obviously a very kind soul, expecting Dr. Leslie to rise to the occasion, which he did, and provided some cough mixture. But when the husband returned home from work, he found his wife really very ill, shivering, and suffering from severe sickness. He went to his employer, who brought some brandy, but sadly, Mary Day died in their presence. When the coroner's inquest came to view the body, appallingly they found it where it lay, exposed and unattended save by the husband. The coroner found that poor Mary Day had died on April the 18th in the chalk pit from dropsy, the result of heart disease accelerated by exposure, consequent upon the want of proper and sanitary accommodation in the parish. Coming back to Petersfield, however, one of the persons giving evidence was Robert Pledger. He was a blacksmith living in Dragon Street, and in the 1871 census, for the first time, he's described as an invalid. So I wonder if he was injured at work. Although he was attended on by Mr. Moore, the district medical officer, it was at the behest of the Independent Order of Foresters. And we might presume that as a mutual benefit society, to which Pledger could afford as a skilled craftsman to contribute, This was Pledger's entitlement. Accordingly, Pledger's vote was upheld, in, of course, potential contrast to those who were in receipt of charity. We get to Friday morning, and the tribunal then started totting up the effect of all these individual decisions. Because the registrar brought in all the ballot papers. And after a few minutes, Counsel for Stowe proudly announced that at this point, Nicholson had got a majority of 1. And another jolly vote goes down, a majority of 2. But that then is back to a tie when 2 Nicholson votes are struck out. And so it went on. There were amusing exchanges concerning the case of George Withers. He was living in Froxfield. I can't quite work out where, but it's close to Barnetside Cottages. And he suffered from lumbago. He was treated at parish expense by Dr. Peake, but he denied entirely being attended by the doctor or even ever having lumbago. Sergeant Ballantyne questioned whether a man who suffered from lumbago would be likely to have forgotten such a painful complaint, but nonetheless, that got nowhere. The evidence of the good doctor was relied upon by the judge, and the vote was lost. And by the time all the challenges to those who were on the register but had obtained parish relief after the 31st of July 1873 were disposed of, where were we? Back to a tie, 352 votes each. The 1664 will of Berriton botanist John Goodyear, who lived 200 yards away down in Spain, but literally just in Berriton, established a charity with a fund created to send forth and put abroad poor children, and the remainder to be distributed amongst the poorest parish inhabitants. A number of votes were challenged on this basis, and of 16 votes lost in this category, 15 were Johnnies. Other classes of potentially disqualified voters included those not resident within 7 miles of the borough, but who were enfranchised by property ownership, and those whose occupation rights fell short of tenancy. Here we found a railway crossing gatekeeper at Liss, living in a trackside cottage. He was very deaf, and much to the amusement of the assembled company, he was asked how he knew the trains were coming if he couldn't hear them. "No, but I see them," was the retort. He ceased paying his rates a long time previously, and he was not going to restart. Likewise, a signalman paid 17 shillings weekly when in occupation of his cottage, had 2 shillings stopped. He was on duty, just think of this, from 6 a.m. to 9 p.m. Now, I know there weren't that many trains passing through, but nonetheless, that's a 15-hour day. As his occupation of the cottage was only by virtue of railway employment, and he could be evicted at any moment, his vote was lost. William Carpenter, a farm labourer from Berriton, voted for Jolliffe. Asked what gave him his right to vote, he replied, "Nothing but his labour." Employed to milk the cows, he lived in a cottage with no rent specified, and the judge ruled there was nothing to suggest the man was a tenant. His vote too was struck out. By now we've reached Saturday morning, and the judge reflected that perhaps he'd been a bit hasty in one decision, but he wasn't going to go back on it. He said the guiding principle when looking at all these cases was whether the house was ancillary to the service given by the occupier. In that case, he wouldn't be a tenant. More similar cases were dealt with on Saturday morning, including Mr. Seward Shepherd, who candidly admitted that he supposed his wages were so much a week and a house. Jolliffe loses another vote. The Jolliffe's barrister started conceding that if the law was the way the judge contended, there was no point in going through any more bit by bit by bit. But these people who shouldn't have voted, if they get back on the register next time, that's perfectly appropriate. It's unclear why, from the newspaper reports, the tribunal now returned to another instance of medical relief. It may just be the way, parish by parish, the opening of the ballots were dealt with and the counterfoils numbered numerically. Richard Evans of Steep, his wife was also in the county lunatic asylum, but he actually made contributions to her upkeep, perhaps surprisingly. But because it wasn't a full contribution that he made, it was held he was still in receipt of effectively parish benefit, and he lost his vote. Despite that, Evans having voted for Nicholson, on countback, we've gone from being level paying a tie to a Jolliffe majority of 1. And just at the death, the pendulum swung back. The Reverend Hawker enters the fray. In the very early part of proceedings, it has been suggested that he, as Vicar of Steep, has been overtly generous in his hospitality in support of Captain Jolliffe. Now that insinuation was in fact subsequently withdrawn. But his personal vote was now challenged. He obviously voted himself for Jolliffe, but it was challenged on the grounds of non-residence. And what had happened, it transpired, is that he'd left the parsonage house for 3 months and gone away on holiday. He'd retained some degree of control of the property by keeping a couple of his servants and his coachman in the house. And the judge thought, well, that doesn't create a break in residence. Some legal argument followed, as a result of which his wife was called. And she accepted that the servants and the coachman were left in the house, but then said, although her husband had come back to Steep within the 3 months, he'd then gone off and stayed elsewhere. And the judge felt that this was the killer dinner and struck his vote off. It landed up a tie. Now, if the judge were correct, what did the lawyers think about how the election should be decided? Did the returning officer have a casting vote? Was it the judge? Now, we know that on the issue of corruption, Henry Stowe had lost, and he'd have to pay the cost of that. If the final result was that Jolliffe was ousted on the scrutiny, Jolliffe would have to be responsible for the rest of the costs. The election court hearing comes to an end. Nothing therefore actually decided, beyond the fact that everything would depend how the Court of Common Pleas in London interpreted the approach to the scrutiny. But for that last gasp equaliser, to use a footballing metaphor, relating to the Vicar of Steep, there would have been no need for a higher court to decide anything, as Jolliffe would have won by a single goal. Now, we could today, but we won't, follow the passage of litigation that ensued with the case getting entangled with other matters and listed with other scrutinies for ultimate decision. But at the end of everything, 3 days of hearing in June, the court decided to give a reserved judgment because it was a matter of sufficient general importance. Lord Coleridge pointed out that Nicholson will be entitled to the seat if the register were not conclusive on the part of all those who voted for Captain Jolliffe, or if some or all of them came within the provisions of the Ballot Act. But what Lord Coleridge decided was that receipt of arms, non-occupation of qualifying premises, or residing outside what in the Petersfield borough case was a 7-mile limit, did not satisfy the relevant provision in the Ballot Act, which was only geared to persons such as peers of the realm, who were disqualified, women, inevitably, in that era, and a restricted class of office holders, as well as felons. Not an exhaustive list, but it showed the type of circumstances in which the register would remain open to challenge. So later that day, Tuesday the 23rd of June, the Speaker of the House of Commons rose to announce that Sidney Hilton Jolliffe had indeed been duly elected for the borough. Now, what the Petersfield election challenge, although unsuccessful, did, through the formal decision of Stowe and Jolliffe, was to establish principles as to the conclusiveness of the electoral register. In the circumstances of mid-Victorian electoral law, people who received parish relief or alms were disqualified from being entered on the register of electors. But once registered, if they then later received such relief, they could still properly vote. But, almost inevitably, the next annual register, they would come off. Although political enfranchisement in Britain has resulted in universal adult suffrage, repealing each of the Reform Acts successively, Stowe and Jolliffe remains good law. If we forget the legal niceties, what the challenge did do, thanks to the removal of stamp duty in the mid-1850s and the subsequent burgeoning of press reporting, was to leave us with a wealth of detail of the life of a country market town. We wouldn't have known of Richard and Mary Gould and how they got their tenancy, nor Richard Evans, the hours that signalmen worked, nor the finer details of election hustings in the 1870s. The first part of the election challenge had dealt with issues of bribery and the like, corrupt practices. And although that part of the challenge failed, what it did reveal was the perception that such activity was rife when an election might be close. The 1876 Reform Act not only enlarged the male franchise, but it also removed the dissolution of Parliament on the death of the monarch. Just fancy that provision would have terminated this Truss's premiership even sooner. We've already noted that one of the unsuccessful arguments raised by Valentine related to the forbidding of voting by those employed for reward by a candidate as canvasser, agent or the like. But the next section of the Act reflected the wide-ranging extent of parliamentary corruption that was still employed. Section 12 recited that in view of corrupt practices that had been extensively employed at the preceding elections in the boroughs of Totnes, Reigate, Great Yarmouth and Lancaster, those boroughs would from the end of that Parliament rap over the knuckles, cease to elect any members to Westminster. We can therefore say that any closely fought contest might be expected to be subjected to potential vote rigging. We can see this in the parliamentary constituency of Wakefield, which in 1868 the Liberals had won in a very narrow majority. 1874 the result was challenged at the same time that the Bolton Evening News was reporting about Petersfield challenge at the Corn Exchange. They were covering evidence produced from Wakefield where large numbers of witnesses told of being given money to vote for the Conservative candidate. Benjamin Warder Blacksmith told of receiving £2.10 shillings, whereas the price of a labourer, or his vote, was £1. And because of that, within days, the Wakefield result was declared void for corruption, and because it was void for corruption, a writ for a by-election was issued. In fact, in that case, the Conservative got back. But that might all explain why the first witness that was ever called by Sergeant Valentine in his attempt to overturn the Petersfield result was a certain Henry Hawkins. Hawkins was a police officer, I think he was from Waterlooville, dressed in mufti, and he was down to report to Nicholson's election agent. And he told the court of doings at the Trooper Inn in Froxfield and the Cricketers Inn at Steep, and the hospitality, the Reverend Hawker, there offered. Now, why would he be there, keeping an eye in advance of the election, if the Liberals didn't suspect in advance there might be some gerrymandering on the part of Jolliffe to secure the captain's election at the expense of William Nicholson? At the end of the day, Jolliffe had been returned to Parliament as member for Petersfield, but it's his swan song. Growing family disillusionment with the town would mean that although he'd followed Nicholson for a few years as chairman of the local bench, on his sudden death in January 1912, all family links with the town were severed, and the name, of course, remains in Hilton Road, and more recently, just round the corner here, Jolliffe Court. And the remainder of the Jolliffe lands and ground rents were put up for sale by auction in 1911. Nicholson, who's rebuilt in magnificent Gothic revival-style Privet Church, with its huge spire visible for miles around. Well, that's all for a parish of a couple of hundred people. But he did that at great expense in 1876. He provided the land for the rebuilding of Churches College up in Rams Hill, and he was ultimately returned to Parliament in 1880 as a Liberal. He never, after 1885, represented even the wider constituency, but his son did as a Conservative for the best part of a generation. And William Nicholson himself died in 1909. Jolliffe versus Nicholson pitched Conservative against Liberal, but above all, it represented old wealth that had long ago been established in landholdings against new industrial money in the shape of the gin distilling Nicholson family. It seemed, however, to be a last hurrah for the former. In Jolliffe and Nicholson, Eton was pitched against Harrow. In Petersfield, Harrow may have lost in 1874, but a few months later, 80 miles away, and later to be educated at Harrow, there would be born arguably Britain's greatest Prime Minister, a certain Winston Leonard Spencer Churchill. Thank you. I'm happy to try and answer any questions. You'll have gathered that an awful lot of the material that I've been able to access came from two sources that are readily available. Firstly, old newspapers, which you could get in through the British Newspaper Archive, and census material which you can pick up from Ancestry or Find My Past, the principal commercial organisations. Obviously, you've got to trawl all the way through. It's great that we've got that.
I have a question for you,
Yes.
or after you, sir.
After you.
What we call the electoral roll, they call the register.
Yes.
How is it compiled?
Good point. Because, of course, we didn't have local authorities, did we, in those days, to send...
Who compiled it? Perhaps is my question.
Yes. Who compiled it? Honestly, I don't. I'd never actually thought. I say yes. Well, at the next election, somebody must have done it. What was
And
it?
there should have been inquiries as to the qualification of the
Yes,
individual.
I suspect.
The thoroughness of that was the cause of the problems.
We do know that the electoral registers in earlier days were sometimes kept by those people that we would now regard as independent. It wasn't until 1894 that we landed up with the current scheme of Petersfield Urban and Rural District Councils and Councils. I will happily look that one up and let you know if you give me your email address. Because it's work.
Well, I was curious about the fellow who lived in the churchyard,
Yes, Richard Gould.
Richard Gould, who was dismissed. How did he get there in the first place?
Well, he wasn't actually dismissed. He wasn't dismissed. What Sergeant Valentine was trying to do was to say that this is an example of undue influence that Jolliffe is using. And what the judge said, no, it wasn't undue influence at all.
beg your pardon, it wasn't him I was thinking of. The fellow who declared he was a tenant and the judge said no, he wasn't a tenant, was he a labourer?
Yes.
How did he get on the list?
Through the process that we don't understand.
Through the process.
Yeah.
Yeah.
Is it possible they were registering births and deaths and marriages
It
at
could be. It
that
could
time?
be
I just wondered whether there was
linked to
also
that.
something in that process.
Yeah.
That would have been done in the church.
Yeah, so
the
the
church
in the
process.
church records.
We've got church records, but from 1836, we've
Seven.
Thank you. It was enacted 1836. I think it came in 1837. We've got civil registration, and I just wonder whether
That's what I was thinking.
the civil it was dealt with through the civil registrar of births, deaths, and marriages, because he would have access at the very lowest to be able to determine if local people were of full age.
The question I was going to ask, I'm struggling a bit to grasp why, and I think I possibly know the answer, why it would, under the legislation, you would be disqualified by reason of being in receipt of parish relief. Presumably because you're not a